last summer, many of you all watched a video that I made regarding the Salt-N-Pepa lawsuit against UMG, trying to establish their rights to their music. Well, trying to literally terminate their rights that they allegedly granted over to UMG. And of course, UMG responded, and that lawsuit was filed like around May in 2025. But here we are. The judge has now finally ruled because UMG filed a motion to dismiss for failure to state a claim. And this is going to be easy because I often talk to you guys about before you engage in any contracts, transactions, before you even agree to anything verbally or written, you always have your attorney present. And this is definitely a textbook one-on-one example of how this should play out. But nonetheless, let's look at the judge's order here from this motion to dismiss against Salt-N-Pepa. And just for background, if you guys want to find out more about the original lawsuit, go back and watch that video that I did. I went through that actual case pretty thoroughly. But now basically, we all know Salt-N-Pepa, who are a legendary hip hop group. I believe they were recently inducted into the Hall of Fame, the Music Hall of Fame. And they have been doing this since 1986. They put out a slew of albums and a slew of work. And here we are, you know, and as you know, under the federal U.S. copyright law, section 203, artists, after a certain amount of period, a certain amount of time, they can terminate the rights that they granted over to the record company initially. And typically, if you do that after 1978, it'll be 35 years. If it was done prior to 1978, it's 56 years. So let's look at what happens here. According to this complaint, this is the judge's order and opinion. This is what the judge ruled on. So let's go through this real briefly. And we see here in 1986, the plaintiffs, which is Salt-N-Pepa, entered into a contract with a recording company called Noise in the Attic Productions Incorporated, NITA for short, NITA, NITA. And this recording agreement was a company that was owned by their producer, Herb Azor. And in this agreement, it shows here, and see, this is why I wasn't able in the first video to actually give you guys a solid determination of what I think was going to happen, because we don't have access to the evidence, whereas this court does, because a lot of evidence was submitted and the judge had to take in everything. And here you're going to see excerpts of the relevant sections of the actual of the actual contract that Salt-N-Pepa entered into. And as you can see, in 1986, they had a recording agreement with Noise in the Attic Productions, NITA for short, with Salt-N-Pepa. And here's parts of the agreement. It says right here, with respect to the company, NITA, providing artists, Salt-N-Pepa, with production services, as well as respect to artists, Salt-N-Pepa, rendering artists exclusive personal services to Noise in the Attic Productions as a recording artist. And that's your typical recording artist contract with a record production company. And so, but here's the important part of that contract. This is key right here. This is going to be key. Remember, I said this towards the end of the video. Remember, I said this part right here. And when you go to the rights section of that same contract, the contract was entered into, it says here, May 15th, 1986. In the same contract, in the rights section, it says, as between the company, NITA, and Salt-N-Pepa, NITA shall be the sole and exclusive owner of any and all rights, title, and or interest in and to master recordings recorded hereunder, including but not limited to worldwide sound copyrights therein and the renewal rights thereto. That is key, because it says right here, who's going to be the owner? Who's going to be the owner of these recordings? It just says right here, NITA, Noise in the Attic Production, a Herbazor owned company, is going to be that's their initial contract, May 15th, 1986, with this production company. That the production company is the sole and exclusive owner of any titles that and rights that they have. Stop right there. You don't really have to go any further, but we will. But that is monumental. And when they sat down and signed this, I would imagine, this is 1986, May 15th, I would imagine the plaintiff, Salt-N-Pepa, was, I don't know, in their 20s. I have no idea, but they were very young. And quite frankly, I would wonder if they even knew what this legalese meant, which is why I always say, have your attorney present with you. But anyway, it states right here very clearly that the sole and exclusive owner is NITA, Noise and Attic Productions, owned by Herbazor. The same day, look what happens, the same day that he entered the contract with Salt-N-Pepa, that same day he entered into a distribution agreement with Next Plateau Records, Inc. And the plaintiffs, Salt-N-Pepa, were not signatories of this agreement. This agreement was literally between Noise in the Attic Productions, which is a company owned by Herbazor, and Next Plateau for distribution purposes. And look at the language in this contract. This is key. It says, in the 1986 Next Plateau agreement, Next Plateau Records engaged Azor to produce and deliver sides. And sides, it says right here, are physical recordings embodying the performances of the plaintiffs, Salt-N-Pepa, regarding the sides that have already been recorded. So they already recorded some when they started this, but regarding the sides that have been recorded, it says, upon the execution of this agreement, producer Herbazor shall deliver to company Next Plateau Records the sides embodying the artist's, Salt-N-Pepa's, performances. So whatever they already recorded, he's gonna go ahead and deliver it to Next Plateau Records. And it says, producer Azor warrants and represents that the producer is the sole and exclusive owner of these sides and all right and title and interest therein. And look at this last part right here. Producer Azor hereby sells, transfers, and assigns to company Next Plateau for the world all aforesaid right, title, interest in and to such size, including without limitation to sound recordings. Okay, if he is selling, transferring, and assigning, that means he owns it. All property law works the same in this regard. You can only transfer, sell, convey only the property that you own. And it says clearly right here in 1986, that same day, 1986, he entered into a contract with Next Plateau and says he, Herb, from NITA, Noise in the Attic, is selling and transferring all the rights of those sides that they already recorded. But what about the future recordings? Well, it addresses this right here. In the same contract, it says, as for sides that will be recorded in the future, the same agreement provides that all sides recording during the term shall be recorded by producer Azor on company Next Plateau Records' behalf, and all records made therefrom together and performance therein shall, from the inception of their creation, be entirely the property of Next Plateau Records in perpetuity. In perpetuity is problematic, but I'll discuss that some other time. But courts really disfavor those types of terms. But that's what's said here, and that's what Herbazor from Noise in the Attic Productions has agreed to, basically saying whatever we've done with the plaintiff, Salt-N-Pepa, whatever, all the music that we recorded before is yours. I'm transferring it to you. I'm selling it to you. I'm giving it over to you. And what we do in the future during this contract term, however long this contract is also yours, Next Plateau Records. And so on and so forth. Now, here's the thing. Salt-N-Pepa themselves sent an attachment to this contract. Now, remember, they're not a part of the contract. They are not a part of this Northern Attic Next Plateau contract. They instead send a letter of inducement. Inducing just simply means I'm trying to persuade you to do something. And it says right here, there were two attachments to this agreement. One was a co-publishing agreement, and the second attachment was an inducement letter dated the same day, an inducement letter signed by each of the plaintiffs, Salt-N-Pepa, and it was addressed to Next Plateau Records. And here is the inducement right here. It basically said, hey, we specifically guarantee the performance by producer Azor and all of the warranties and representations and covenants made in the agreement. I hereby make all warranties and representations made to you. That is literally them saying, we hereby understand, and we say whatever was in that agreement with you and Northern Attic, we want the same thing. We are warranting the same thing, and that's why we're inducing you to go ahead and get into a contract with Northern Attic, not us, Northern Attic. And it says here that in said agreement to Next Plateau Records, we grant you all the rights and remedies therein that's already been granted to you, and agree to perform all obligations therein. So they are agreeing to perform everything that Herb had already warranted and represented that they would agree to. Again, that's just their letter of inducement telling Next Plateau, yeah, go ahead, and we'll go ahead and still perform the obligations that you and Herb and Northern Attic agreed to. That is key. Now, if you go further, what happens next? I mean, we can fast forward through all this, but basically, and it says right here, now Next Plateau owns the recordings, and on July 1st in 1992, which is 6 years later, the plaintiffs and NITA entered into an agreement with London Records, where London now becomes the owner and they make the same warranties and representations to London Records to record, and London also, all of the next, it says right here, all of the Next Plateau's rights and obligations under the 1986 agreement have been assigned by Next Plateau to London Records. Now, 1992, London Records takes over, and then shortly thereafter, Universal Music Group, it says right here, becomes a successor in interest to both Next Plateau and London. So, sometime after the 1992 agreement with London, Universal comes over and takes it. And then in March 22nd, 2022, which is 36 years later. Remember I told you about the copyright law that allows you to terminate? You have to wait 35 years if you sign an agreement that came after 1978. Well, theirs came in 1986, which is clearly after 1978. And 36 years later, it says right here, March 22nd, 2022, they sought to terminate the copyright ownership from UMG. Now, we see the problem now. Therein lies your issue. They are trying to say, hey, Universal, the rights you have to all of our copyrights, all of our sides, all of our material, all of our music, now under the federal copyright law, you got to get it back. The problem is the copyright law is only for authors who own the actual copyright. Since they never owned it, and they never owned it, they could not have never transferred it. If they never transferred it, then how can they come back 36 years later and says, hey, give it back to us? But what did the judge say, right? What did the judge say? I mean, that's what I'm just seeing thus far. But what did the judge say in all of this? Because now we know what's going on. You know how it started with, basically in a brief summary, we know how it started in 1986, Herb Azor, Northern Attic production. Then it goes to Next Plateau Records the same day, 1986, and then in 1992, goes to London Records, and then after that, Universal takes over. And in 2022, Salt-N-Pepa says, hey, under federal law, give us our stuff back. Well, you can't do that. But what does the judge say? What does the judge say here, right? It says right here, Section 203 provides artists an opportunity to terminate prior grants, transferring the license or copyright if it was executed on or after January 1st, 1978, 35 years after the grant was executed. Okay, that's what I already mentioned. But it says termination of said copyrights is available for all transfer executed by the author except for those related to works made for hire. And that was UMG's entire argument. If you remember, they kept saying Salt-N-Pepa works for hire. They never owned it. UMG asserts that the First Amendment complaint fails to plead that Salt-N-Pepa previously owned and transferred the copyrights at issue. It says UMG claims that the 1986 agreement, on which the plaintiffs rely on, do not establish that they ever owned the copyrights to their sound recordings, let alone transfer them to anyone else. Instead, UMG contends that the rights, that these documents reflect that Noise in the Attic, NITA, was the exclusive owner of the rights and transferred them to Universal's predecessors, which was Next Plateau and London Records, and then down to Universal. That's what the judge here is echoing what UMG filed. Now let's go on further. What does the judge further say? The judge says, even viewed in light most favorable to the plaintiffs, the 1986 agreements do not indicate that the plaintiffs, Salt-N-Pepa, ever owned the copyrights to the sound recording or that they granted a transfer to these rights to anyone else. It was only Herbazor and Noise in the Attic that granted a transfer of those rights to Next Plateau Records. And then it goes on to talk about how they did it, which we already went over. The judge says, the absence of a contract evidencing a transfer of rights by the plaintiffs is not surprising. As UMG notes, the shall be the sole and exclusive owner language in the 1986 agreement indicates that they are likely works for hire, which are excluded from the Section 203 termination mechanism. This is now, the judge further goes on to say this, although this opinion does not reach the issue of whether the recordings were in fact works made for hire, but such a classification is consistent with the copyright registrations for each of the sound recordings listed on the plaintiff's notice of termination. And the copyright registrations, they all list, as you see here, they all list the authors of these sound recordings as Next Plateau Records Incorporation, employer for hire. Then London Records, employer for hire. Then UMG Recordings Incorporate, employer for hire. Whenever you work for a company and you provide the work, you are just a work made for hire. Even though the judge is saying, hey, we're not gonna go ahead and deal with that issue, but it does seem consistent that Salt-N-Pepa in this case were just merely works made for hire. And how the judge conclude this? The judge actually deals with the second part of their claim, which is conversion, which is basically where under New York law, conversion is the unauthorized assumption and exercise of rights of ownerships over goods belonging to another to the execution of another's rights. Well, we already went over that. They can't make that claim because they never, they being the plaintiffs here, Salt-N-Pepa, never owned it. So of course, the judge has ended all this by saying, in conclusion, the First Amendment complaint alleged that the plaintiffs are the true owners of the master tapes, but such an allegation standing alone without any factual detail supporting this claim to ownership is conclusory and cannot be accepted as true. Thus, they failed to plausibly allege a conversion claim, an ownership claim. So in conclusion, the judge dismissed Salt-N-Pepa's claim against UMG. You know, the lesson to be learned here is what I've always told you. This happens more often than you would imagine. I see it all the time. As you know, I'm a sports and entertainment attorney here in Hollywood, so I see this regularly, and I often tell them, hey, I cannot be more emphatic to state that before you agree to anything, whether this agreement can be verbal or written, because not all contracts have to be in writing, only some. And there's a list of that, but I won't go into that legal issue right now. But before you agree to anything, I always tell my clients to say this one line, well, let me take it to my lawyer first and go over it with my lawyer. That's all you have to remember. Salt-N-Pepa, this is going to be a tough blow to them because we do love Salt-N-Pepa. They are hip-hop royalty. As far as I'm concerned, they are icons. They put in so much work and they've given us so much great entertainment over the years. I'm sure they'll bounce back from this because they are still going. They're still touring from my understanding, and they're still very, very well respected, except that in this particular case, a lot of artists that I counsel on this, I tell them, hey, man, get your copyrights back so you can pass that down to your lineage, to your children, to your family members, to whomever. Instead, they won't be able to do that, at least as of right now, because Salt-N-Pepa, their statement that they say that, here's a statement that Salt-N-Pepa made after this ruling came out. Say, we respectfully disagree with the court's decision and fully intend to pursue our right to appeal. And they have that right to appeal. I'm not sure what's going to happen out of that, but we'll follow and see. But it is important to note that Universal, their statement after this ruling, the UMG said, while we are gratified that the court dismissed this baseless lawsuit, it should never have been brought in the first place. Prior to this suit, and without any legal obligation to do so, we made multiple attempts to resolve the matter amicably, to improve the artist's compensation and ensure that Salt-N-Pepa's fans had access to their music. Even with the court's complete rejection of their claims, we remain open and willing to find a resolution to the matter and turn the page so we can focus our efforts on working together to amplify Salt-N-Pepa's legacies for generations to come. So Universal said, hey, even though we don't have any legal obligation to do so, we'll still work with you. That's what they're saying. Of course, Salt-N-Pepa said we're going to appeal. Nonetheless, these are things that you need to learn from. This is so important. This is a big, big case. And I tell artists all the time, be careful about what you agree to. I cannot be more emphatic. I cannot, and I mean, at the risk of being redundant, I have to keep saying it because for some reason, artists, athletes, entertainers, they just are so like, they're like, oh, okay, I got it, and then they forget, oh, I forgot, and then here you are years later. And it always is gonna cost you more later than if you take care of it up front. So I wanna hear what you guys think of this. According to the judge and according to the contracts, they never owned it. They simply just gave it all over. They admitted in the contract that, hey, it's gonna belong to this party. And then it went on down the line and they came back 36 years later and said, hey, we want to get it back, but they never had it in the first place. So what do you guys think? Do you guys agree with the judge's ruling? Do you think Salt-N-Pepa will bounce back from this? They are hip hop icons and we love them. So I would love to hear your thoughts on this. Put it in the comments below. Remember to like, comment, share, subscribe. I would love to hear your thoughts. It's your brother, Attorney Jeff.